Provision: a judge may grant as an alternative to imposing a jail sentence. Provision is ordered when the circumstances and seriousness of the crime suggested by the provisioner is not a threat to society, and that incarceration is not an appropriate punishment. The provisioner may freely live in the community but must abide by a certain condition of provision for the period of time specified by the court and report regularly to an appointed provision officer. General condition of the provision may include living where directed, participating in rehabilitation programs, submitting to drug and test alcohol, and maintaining employment. Provisioners may be required to show proof to the court that they have complied with all conditions of provision. If a provisioner fails to comply with a required condition, the court may revoke probation and require provisioner to serve a jail sentence.
Parole is the conditional release of prisoner from correctional institution after serving the minimum period of prison sentence. A parole mao na ang pagpagawa sa usa ka prisoner after niya masilbihan ang minimum nga niya nga sentensya. Palayaon siya but under certain condition or under supervision samtang gisilbihan niya ang nabilin na sentensya gawa sa prisuhan. When we talk about parole, the law that we should bear in mind is Article number 4103, the Indeterminate Sentence Law, meaning indeterminate ang sentensya, dili fix, dili pod exact. Gitagaan ka og sentensya nga nay minimum ug maximum depende sa kadaghanon sa mitigating or aggravating circumstances. For example, ang penalty sa kaso nga pagpangawat kay na may minimum nga 6 years, unsa nay maximum nga 12 years. Mao na sa gitawag nga indeterminate sentence, why fix nga number of years sentence. Sa kaning atong example, when we talk about parole, kinahanglan sa kamoserve sa minimum sentence nga 6 years, mapriso sa kag 6 years before ka maka-apply og parole. Parole is the conditional release of prisoner from correctional institution after serving the minimum period of prison sentence. Who may grant parole to a prisoner? The Board of Pardons and Parole is the one who grants the parole to a prisoner. This is an agency under office of the Secretary of Justice. This will be further be discussed by my group mates. Who cannot be granted parole? Generally, it is not allowed to grant parole to a prisoner who is sentenced to a term of imprisonment of 1 year or less, or to a straight penalty and those fixed penalty, meaning ilang penalty kay wa may minimum term like death penalty and life imprisonment kay wa man ni sila'y minimum og maximum, mao na siya gitawag og indeterminate sentence. How long is the period of parole? For example, ang minimum sa imong sentensya is 10 years. Ang maximum is 16 years. Unsa ang grantahay imong parole, syempre after nimo ma-serve ang minimum nga 10 years. Ang imong parole maglast na laman og 6 years kay 6 years naman lamang ang remaining sa 16 years nimo nga sentensya. Meaning mahuman imong parole until expiration or pagkahuman sa maximum sa imong sentensya. Mag-serve gihapon kag 6 years sa gawas sa prisuhan para mahuman ang imong maximum sentence nga 16 years. What happens to a parole if the conditions of parole are violated? The parole shall be rearrested and recommitted or returned to prison to serve an expired portion of the maximum period of his sentence. What is the document released to certify that parole is successfully completed by the parole? After the expiration of maximum sentence of a client, the board shall, upon recommendation of the Chief Probation and Parole Officer, that the client has substantially complied with all the conditions of his parole or pardon, shall issue certificate of final release and discharge to a parole or pardon.
Executive clemency refers to reprieve, absolute pardon, conditional pardon, with or without parole, conditions, and commutation of sentence as may be granted by the President of the Philippines. Commutation of sentence refers to reduction of the duration of a prison sentence of a prisoner. What does executive mean? It is the power of president or governor to pardon a person convicted of a crime or commute a sentence to be served. Who qualifies for executive clemency? It is simplified requirements and procedure apply to petitions of inmates qualified for parole of executive clemency, as well as applicants who are 65 years old and have served at least 5 years of their sentence, or those whose imprisonment is inimical to their health as attested by physician. What is the difference between probation and executive clemency? First, probation and parole are much similar to each other than a pardon are. While both probation and parole are used as an alternative to a jail or prison time, pardons are given by a higher government powers in order to wipe an offender's record clean and free from any remaining penalties. There are four powers of clemency. The term pardon is often used generically to describe the power vested in the head of state to grant clemency in individual cases. In this sense, it includes such subcategories as full pardon, conditional pardon, commutation, remission, and reprieve. There are three there are three types of executive clemency. A part of executive clemency: the commutation of sentence, the pardon, and the reprieve. Commutation of sentence is a reduction of a sentence to a lesser period of time. This may occur for some of the same reason a pardon may be granted. While pardon is a complete forgiveness and restores full rights of citizenship, normally those who have been convicted of a crime forfeit certain rights, such as to serve in certain rules and to hold public office or vote in an election. But a pardon restores those rights. Those pardoned can apply to be expunged and be able to say that were not convicted of a crime. While the reprieve is a delay or temporary suspension of punishment. Typically, reprieves are granted for very specific and unusual circumstances, such as illness or family emergencies. That is all. Thank you.